I hope that whilst missing meeting everyone in person, which of course is what we're all about, you will find these online events interesting, informative and valuable, and certainly the feedback to date has been really positive. We also hope that you and your families continue to be safe and well, and hopefully adapting to the various changes and restrictions that we've all had to deal with, and of course those that are coming towards us at the end of this particular week. I actually recall discussing with the club's board at the beginning of the pandemic whether we would actually be able to start the season, this new season, in person, and the feeling was probably a 50-50 chance, but alas, we do seem a long way away from that at the moment. So as a reminder, although unable to hold our physical events, we have been keen that the club should still perform its unique role of drawing together such a cross-section of Cardiff and wider Welsh life to listen to prominent speakers talk about the issues of the day. And as I've said, we've received considerable support over recent months, and in particular from our season sponsors, Cardiff Metropolitan University and Odgers, and their support is greatly appreciated, particularly through these challenging times. So the format this evening will follow what seems to have worked for our previous events. I will introduce our speaker, Sir Wyn Williams, and after his address, we will undertake a question and answer session. So as per the joining instructions, please would you send your questions as concisely as possible directly to me by clicking into the chat box at the bottom of your screens, and I will then ask as many as I can in the time that we have available. You have the option of remaining in mixed participant viewing mode, or you can select the option at the top right of your screens and just have the speaker view. You also have the option to leave your video on or off. I'll then conclude the session, which we estimate will probably be around 6:45. So on to the introduction of our speaker. Tonight's guest will be a familiar face to many of our members, and in particular those from the legal profession, which, funnily enough, is very well represented here this evening. Sir Wyn Williams was born, brought up, and still lives in the Rhondda. Educated at Rhondda County School for Boys, Corpus Christi College, Oxford, and the Inns of Court Law School in London. He qualified as a barrister in 1974 and began practicing in 1975 from chambers in Cardiff. Wyn concentrated mainly on civil work, a large volume of personal injury cases, planning cases, and cases involving sports law. In the 2 years immediately before becoming a judge, Wyn acted for the Home Office in cases related to international terrorism. He became a High Court judge in 2007, serving as presiding judge for the Wales Circuit and as deputy chair of the Boundary Commission for Wales until 2017. He is currently president of Welsh Tribunals and a judge of the Courts of Appeal of Guernsey and Jersey. Wyn has been involved with Welsh rugby over decades, and since his retirement as a full-time judge, he's also become a member of the judicial panels for the Premier Football League and the Football Association. I have to also mention that he's proud to be president of Penderys Male Choir and Tealestown Rugby Club. It's now my pleasure to hand over to Sir Wyn Williams.
Am I unmuted now?
Yep, you're good to go, Wyn.
Well, I have to tell you, first of all, that I'm completely petrified at primarily looking at myself on a screen. This is not what I've been used to over 40 years of trying to speak publicly. So bear with me if I sound hesitant and feeling every one of my 69 years as I address you. I think I was billed as president of Welsh Tribunals, and so some of you might have been attracted to listen to a learned dissertation about those august bodies. Others of you may be glad to hear that Paul Thorburn invited me to a different set of priorities, namely to talk substantially, at least, about my involvement with sport as it interfaces with my legal career. And it is true that that will be far more entertaining than if I were to venture a discourse on devolved tribunals. And so in a little while, I will try and entertain you about some of the funnier things that have occurred in my sporting stroke legal career. But I did think that perhaps I should be serious just for a few minutes, since after all, judges are supposed to be serious, at least on occasions. And so what I want to be serious about, if I may, is what I'm going to call judicial activism. In the last 2 or 3 years, if not for longer, there has been a good deal of criticism of judges in the press about so-called judicial activism, which has usually surfaced when judges have to make decisions about cases which are thought to have a political content. Now, as I think we'd all find easy to accept, there are occasions when the dividing line between policy, politics, and the law can be difficult to demarcate. And judges are no more than other human beings in finding some of these difficult concepts to separate. But I don't want to talk about the difficulties involved in it. Rather, I'd like to explain to you that in fact, judges have been guilty, if that's the correct expression, of activism ever since we've had a judicial system. Why do I say that? Well, I say it because the lawyers will probably understand it easily, but the non-lawyers will be familiar with the term. That is, we live under a system in the United Kingdom, or at least in England and Wales, let's be more precise about it, which is very much wedded to the common law. The common law, of course, is a grand phrase to describe the laws that judges have made literally over centuries. Our judges are astute to say that they are very rarely involved in making the law as opposed to applying the law. But if you were actually to look at what has happened over centuries, you might raise a metaphorical eyebrow at such a modest contention on behalf of the judges, because vast tracts of our laws have been made incrementally over centuries. That's all in the abstract. Let me give you a concrete example. In 1930 or 31, a poor lady in Scotland thought she was going to drink from a bottle of ginger beer and enjoy the taste. What she got was a horrible taste because inside the bottle was a decomposing snail. The lady hadn't purchased the bottle herself. She'd been given it by a friend. So she couldn't complain about the injuries which she suffered by suing anybody under the law of contract. Now, today we would automatically think, well, what's the problem? Someone must have been negligent. Surely she would sue for negligence. Well, in 1932, when the House of Lords had to decide this point, it was completely novel. A special reference was made to the House of Lords in order to determine whether a lady in her position could recover compensation by virtue of someone negligently either introducing or failing to remove the snail from the bottle. The House of Lords was split about it, 3-2, and a famous judgment was given by a famous Welshman, or at least a man famously connected to Wales, called Lord Atkin, which held that the lady had a remedy in negligence. Now that is, the perfect example of what we would now call judicial activism. It was the judges making the law to suit the social norms as they were evolving at the time. It was said to be the incremental development of the law of tort, as this was, one building block upon another, which led to that conclusion. But in reality, of course, 5 eminent judges sat down together. 3 of them thought one thing and 2 another. And so the law became as it is now, that someone who negligently injures another has to pay them compensation. Now, those who are worried about the notion that the judges sometimes interfere in political things might well say, oh, well, yes, that's all right, because this was in the concept of a dispute between private individuals. And we fully understand that in that context, it's permissible for judges to develop the law. It isn't quite as simple as that. At the turn of the 19th, 20th century, our judges were busily making laws which had profound effects upon the relationships between employer and employee. They developed torts of intimidation, conspiracy, and the like, to prevent workmen actively protesting about their conditions of work. The result, of course, was the onset of the trade union movement. So it was one social norm being overtaken by another in a different context. In the 1940s and the 1950s, a famous judge, Lord Denning, made huge changes to the law, almost single-handed, in relation to the law of contract. And for those of you who are present who are interested in matrimonial law, he set norms for matrimonial property, which ultimately became embodied in matrimonial legislation in the late 1960s and early 1970s. So, ladies and gentlemen, the serious bit. Judicial activism is alive and kicking and always has been. And if politicians or citizens, or for that matter, academic lawyers, take the view that judicial activism on occasions goes too far, well, then you'll be glad to know there's always a remedy. Because Parliament is sovereign. And if judges do overstep the mark and create laws which are not universally acceptable, or at least not universally acceptable in the eyes of Parliament, then Parliament has the last word and legislates. And once Parliament legislates, judges apply the law. Of course, there are occasions when judges have to deal with difficult statutory construction points, but when they are doing that, they are seeking to apply the law. So, in defense of judicial activism, I would simply say this: Parliament cannot legislate for all eventualities. The judges have a role to play in ensuring that law develops incrementally. And I venture to suggest that our system of common law, replicated as it is in many countries of the world, usually gets the balance right. But judges are human, and sometimes they overstep the mark. So what's the great surprise? So that's enough being serious. What about sport and the law? Well, I've thought of the occasions when I've been involved in sport and the law now over 25 years. And I'd like to begin with a little tale about a Fijian player who was playing rugby union for Sale in a European Champions Cup game against a French team. And he unfortunately decided that during the course of a maul, he would bite the arm of a French player. So that wasn't particularly a good thing to do, as you might think. And so he was hauled up, having been sent off, before a disciplinary commission, which I was chairing. And unusually, I was flanked by a member of the Italian rugby union and a member of the Scottish Rugby Union. And we were hearing this case and we were wondering what it was that the player was going to say. And it was a most unusual hearing because his representative, who I think at the time was the chief executive of Sale, came along to explain to us how it was that he'd committed this offence, that it was terribly out of character, and how he would never do such a terrible thing again, etc. And it was true that it probably was very much out of character because the player had a very good disciplinary record. And right at the end of the hearing, as you do in these kinds of situations, I said as the chair to the player, well, would you like to say anything yourself? And he looked me straight in the eye and he said, yes, it was only a nip. And the Italian didn't have a clue what he meant. And the Scotsman thought he was referring to whiskey. The joke would be much better if I could be there with you. But that isn't the only time that we've had a good laugh at, at one of these hearings. There was another occasion when the English second row, Danny Grucock, who was a huge man, came before us. And it was really, really very difficult case because Danny had been sent off for about the second or third time. But this time he'd been sent off in close proximity to a Lions tour for which he'd been selected. And obviously, a suspension of any length of time would rule him out of that tour. Now, this wasn't funny. No disciplinary tribunal wants to remove a player from a Lions tour. But it was going to be extremely difficult to avoid that consequence, because the one thing you could say about Danny Grucock was that when he got sent off, he deserved it. In other words, if he landed a punch on someone, it really was quite a good punch, which is what had happened on this occasion. And so we went through the hearing, and obviously the whole emphasis of what was being said was, how can we try and persuade this tribunal to let Danny go on the Lions tour? I'm sorry to say they failed to persuade us. And I hated that because, you know, I'm a rugby fan. So I didn't really want to have to be the man to tell Danny Grucock that he was not going to go on this Lions tour. But that's what I had to do at the end. And as I say, this wasn't funny, but almost embodied what I would regard as something to do with the spirit of rugby. Because at the end of this process, Danny approached the bench, as they say. There we were sitting at a table, as I'm sitting at my table at home now. This 6'6" giant approaches us. And I thought, gosh, what's going to happen now? And actually what he did was to take each of us by the hand, shake our hands very warmly, and thank us for having the courtesy to listen to him. And I thought that was such magnanimity on the part of a man who must have been desperately disappointed, that has also stuck in my mind. And my third anecdotal story concerns another giant of the rugby world, Tana Umanga. Long before Sam Warburton got sent off in that semi-final against France in 2011, Tana Umanga upended an Irish player in a similar fashion in a game between New Zealand and Ireland in Dublin. Now, at the time, I was actively involved in discipline with World Rugby, and the rule was somewhat different then to the rule as I believe it to be now, though I may be a bit out of touch with this. But then certainly, the disciplinary commission could only interfere if it was satisfied that the referee had got it wrong. So this this incident occurred, the spear tackle, as it's now known, took place, and a very well-respected South African referee, Mr. Kaplan, was no more than a yard away from it when it happened. And so he immediately reached for his card, but it was a yellow card, not a red card. And so Umanga went to the sin bin for 10 minutes. The citing officer thought that this wasn't right, and so he cited him, saying that he should have been sent off. And the commission was convened to deal with it. So we pondered, and we looked at the video, as you do from all angles. And every time we looked at the video, the same thought popped into our head. The referee is standing right by this. He had the perfect view. Why should we overturn him? So we wrote a decision saying that although we objectively might have reached a different view ourselves, simply looking at the video, we were satisfied that Mr. Kaplan had a bird's eye view of everything that had gone on, and that we couldn't possibly say that his assessment of it in real time was wrong. This decision, so I am told, was held up for a while by World Rugby as a model of how one should approach these sort of issues. That's not the reaction I had from Ireland. I had a very, very long letter from the headmaster of a school in, I believe, Dungannon, telling me that I was a disgrace to my office as a judge, because I couldn't possibly have done anything other than ban Mr. Umanga for 3 months if I was going to show any kind of regard for what he'd really done. It taught me a story about the difference between applying the rules and the law as you would like it to be. The headmaster, of course, was right when he said that many people were appalled by this tackle, and he had wished that a long suspension should be imposed. World Rugby were right when they said that we'd applied the rules. I was just glad that I could go back to my day job of being a judge. That normally meant that I was immune from such targets from irate members of the public. Not very often I was a target for some press criticism, thankfully. And now as I fade into obscurity as a retired or almost retired judge, I'm safe in the knowledge that all that I've done is upset you tonight by not being interesting enough. So thank you for listening. I think it's now 18:25. So I think I'm well within the time scale that I was given, and I can revert to what will be a much more difficult task, and that is to answer your questions.
Wyn, thank you very much for that. Really interesting discussion. I'm sure it has stimulated some questions and thoughts, particularly given our Welsh love of rugby and plenty of rugby anecdotes in there. So I open it up as a reminder. If you could send me your questions through the chat function, send them to me, and I will commence with asking Wyn some questions. Who's going to send me the first one? Well, just while everyone's having a think, is it fair to ask you, Wyn, what do you think, sticking with the sport one probably, but you gave a few examples there, but what do you think has probably been the most difficult one that you've had to think through and preside over in sport?
Well, I make no secret of the fact that the most difficult one that I've done, or one of the most difficult ones that I've done, in terms of trying to remain entirely objective, is the rugby case I did most recently involving Robert Howley. Because first and foremost, I'm a Welsh rugby fan. So having to preside over a tribunal which involved, in effect, one of my rugby heroes was extremely difficult for me. I mean, it was a difficult case anyway, given its content. But for me personally, as a Welsh rugby fan, I did find that extremely difficult. And I wouldn't have been surprised if I got it entirely wrong. I know that some people thought I was too lenient. Some people thought I was too hard. Usually, if people are generally kind of half satisfied, half dissatisfied, a judge thinks he's done okay.
Good answer. Okay, we have some questions coming in now. So Rosie Moriarty Simmons would like to know what your views are on sub judice.
Well, obviously, the concept is a valid one. And there is no doubt that in appropriate circumstances, it is proper for one to say, if I've understood the drift of the question correctly, that there shouldn't be public comment on it while there are proceedings in being. Sometimes, as a citizen, I stress, as opposed to a judge, I think we're a little too shy in our approach to it. But I stress that's as a citizen. From a judicial perspective, certainly in many classes of cases, and in particular criminal cases, it's a very valuable tool, because what one has to remember is that in our criminal system, especially in the Crown Court, of course, the fact finder, the verdict maker, are lay people. And so to have significant comment about pending proceedings prior to the court case can, on occasion, cause considerable difficulty for the objectivity of the jury or the fact finder. So as a concept, I think it's fine. I think it certainly has a place in cases involving criminal cases. I think as a citizen, I might say there's been a tendency to hide a bit behind the concept in less sensitive areas. I think that's probably as much as I'd like to say about it.
Thank you for that. Paul Thorburn actually wants to know how you feel that sport has changed over the years in your time in relation to the legal challenges that sport faces.
Well, actually, well, can I start by saying that when I was starting off as a young lawyer, disciplinary tribunals weren't called that. They were called domestic tribunals for good reason, because in truth, they were made up of members of the particular governing body, whether it be the FA or the rugby union, with no sense of impartiality involved. They were simply members of the governing body who doled out the justice. So a domestic tribunal was a lawyer's way of saying that there was something to be said for improving impartiality. Commercially, of course, sports law was in its infancy. I mean, I started my career in the law not that long after professional footballers got rid of the minimum wage. And then just as I was starting, we had the Bosman decision in the European Court, which allowed the transfer rules then applying to be ripped up. So from those sort of small acorns, it's now grown into a multi-billion enterprise with the full panoply of the law attached to it. That's the reality of it. Today, I've been involved in a case which is an appeal by one of the clubs of the championship in the Football League, where the amounts of money at stake are very substantial. Both sides, that's the English Football League and the club, are represented by literally teams of lawyers. The disciplinary commission, or the arbitral commission, sorry, consisted of a former law lord, myself, and a QC. And, you know, it's the Rolls Royce, really, of the legal system. has been in operation in relation to this sports dispute. So we've gone from a system in the late 1960s when, as I say, it was all pretty rudimentary, to a system whereby you get very highly paid lawyers involved in very highly charged commercial disputes, disciplinary disputes and the like, where vast sums of money are involved. So the difference is just enormous, Paul.
Thank you. Next one is from Melanie Hamer, who asks, as a fellow lawyer, originally also from Rhondda I wonder if you envisage judicial activism helping at all in the current pandemic and lockdowns, and if so, in what ways?
Certainly, I envisage judicial activism coming to the fore procedurally. Melanie will know, I know that Melanie is a distinguished family lawyer, and she will obviously know that most cases, not just in family law, but generally, are governed by procedural codes or rules. And obviously, judges have to apply those rules. I do think that they ought to be applied as flexibly as possible in general terms, but certainly in terms of the pandemic from which we are suffering. Just to impinge ever so slightly on my role as president of Welsh Tribunals, we have gone out of our way in Welsh Tribunals to make practice directions and alter our procedural rules to fit the current pandemic. Indeed, the Mental Health Review Tribunal was the subject of criticism for altering its rules in a way which at least some people thought might have the effect of diminishing the quality of justice, though I would personally argue that that was misplaced. But be that as it may, I certainly think that in procedural terms, then we have to be as flexible as we possibly can during this period to ensure that the wagon keeps rolling, so to speak. In terms of the substantive law, I think that's more difficult. I think perhaps I omitted to say, and I should have said it, that judicial activism in reality ought to be confined for the very upper echelons of the judiciary. When I was talking about the cases which I referred to, they were all cases decided either in the House of Lords, as it used to be, or now the Supreme Court. And in my opinion, it's perfectly permissible for the most senior judges to engage in the development of the substantive law. That isn't so easy for first instance judges because, of course, we are subject to the doctrine of precedent. And just as our common law demands that, at the very highest echelons, the judges should be able to develop the law. So it's another central tenet of the common law that we follow the doctrine of precedent. So as a High Court judge, I would be bound to follow the Court of Appeal and obviously the Supreme Court. I would find the decisions of my fellow High Court judges persuasive only. But until you get to the real upper end of the scale, so to speak, I think I would have to say that the opportunity for judicial activism, even in a pandemic, is very, very limited in terms of the substantive law.
Okay, thank you. Next one's from Sam John, who is asking you whether you preferred your time as a barrister or a judge and why.
Well, I always said until I retired that I preferred being a barrister. And I said it essentially for one reason alone. You get huge buzz every now and then as a barrister, which is extremely difficult to replicate as a judge. There's nothing like winning a case against the head, as they say, And no lawyer is immune from that great feeling of winning a case when you thought you were going to lose. And so the buzz that comes with that is hard to replicate as a judge. And I thought that probably that was something that would always tend to make me think that I enjoyed my time as a barrister more than as a judge. Since I've more or less retired as a judge, you begin to realize that there is a great deal of satisfaction to be had on occasion in making a judgment that A, of course, you believe to be right, but B, is thereafter generally accepted to be right. That does also bring with it its own satisfaction. But since my first love, I suppose, has always been sport, because let's be fair, if I could have been Barry John, I would have been much preferred to that than being Lord Atkin, but that's another story. But since my first love is sport, I think the buzz in the end just about wins it out. So I'd say the buzz of winning my greatest cases at the bar outweighs the satisfaction I've had from occasionally being told by the Court of Appeal that I'd written quite a good judgment.
Good answer. Next we have Armin Kier, who wants to know, do you think there is a valid case to introduce a codified constitution?
I think there is a valid case for it, because who am I to say that those developed countries who have codified constitutions have not got as good a system as we have? I think, so I don't doubt the validity of such a development. I think my query would be, is it necessary? And that, of course, leads us back to this very difficult issue, which is the interface between law and politics. Because despite the obvious consternation in some quarters about the decisions of the Supreme Court about who is to invoke Article 50 and was Parliament unlawfully prorogued, on the whole, we've avoided constitutional strains and stresses between the judiciary and the executive. I'm not sure that the written constitution would remove strains and stresses between the executive and the judiciary, because who is to interpret the constitution apart from the judiciary? And if they interpret it in a manner that the executive doesn't like, we're back to where we are at the moment. So I don't see the codification of the Constitution as removing the occasional stress and strain which inevitably comes between the different arms of government. I mean, in the theory of government, it's sometimes forgotten that the judiciary is the third arm. We tend to think of the separation of the legislature and the executive, but it's actually the case that the judiciary is also regarded in the theory of the separation of powers as an arm of government. And so my view is that the strain inevitably will occur on occasions. And I've not yet seen much evidence that a codified or a written constitution actually removes the stresses and strains. And we're about to witness that full on, I suspect, with some of the decisions that the American Supreme Court may be called upon to hand down in the next year or so.
Thank you for that. Marjula Bray is asking whether you've been involved in any drugs testing cases in sport.
The short answer is no. They tend to have specialist panels for the drugs cases, and neither in rugby nor in football have I been involved in them. So the short answer is no.
Okay. Bethan Darwin is asking, do you have a view on Sergio Aguero touching line referee Sean Massey Ellis?
This is where I hide behind my ignorance. I'm not sure I know what happened then, sorry.
No,
Would someone like to tell me?
Well, I'll tell you what, I'll ask you another question. If Bethan wants to elaborate, then we can go back to it, because I don't know either. Paul Foreman's actually back, asking about, he says the case of Gareth Bale. I'm not sure if it was a formal case, but this is Gareth Bale and the apparent breakdown in the relationship between the player and the coach. What options, if any, did Gareth Bale have to help break the deadlock and give him the opportunity to fulfil his playing ambitions? Do you think a panel of arbitrators, would have helped the kind of eventual outcome and made any progress?
Well, obviously, this is highly theoretical because strictly the relationship between Gareth Bale and Real Madrid would be governed by his contract, and I have no idea what was in it. But I have my doubts about whether the law has a role to play in that sort of breakdown. In my years as involved in sports arbitration, sports discipline, I have on occasions thought, and I stress a smallish number of occasions, but there have been occasions when we are approaching these issues a little too legalistically. And I think one gets to the point where one is trying to sort out the personal relationship between a coach and a player, both of them being extremely able in their fields. I'm not entirely convinced that a legal approach is the correct one. I appreciate that there will be arbitrators, and I'd like to think that I'm one of them, who have an empathy with the sport as well as being lawyers. But nonetheless, I've been trained over 40 years to think like a lawyer, in truth. And it's very, very difficult, I think, to imagine that I could have a role to play in sorting out the differences between Gareth and his coach. There is a role for arbitration stroke mediation. I mean, it's, I think, pretty common knowledge that in one of the episodes when the Welsh Rugby Union and the regions were trying to renegotiate their contractual relationship, I helped them by acting as a kind of mediator. But that was a different scenario where what we were seeking to achieve was a blueprint for the future. In other words, a contractual provision to cover their future relationship. We weren't trying to solve a breakdown in human relationships, if I can put it in that way, which may have been, and I stress may because I don't know, what has been at the root of the problem between Zidane and Gareth Bale.
Okay, Wyn, thank you for that. I'm just conscious we are coming up to 7:15 where we said we'd finish. I think we've probably covered most of the questions that I've received. So in which case, really just leaves me with the opportunity to thank you, so much for addressing the club this evening. From my perspective, we've heard a fair bit about judicial activism and the fact that it's alive and kicking, but you've explained the reasons why and that judges, are only human. We heard a bit about the history of various aspects, actually, of lawmaking, and that was really interesting. Of course, we got some really interesting anecdotes about the law in sport and biting rugby players, and the spirit of rugby really came through for me really strongly. And I have to say, I thought that was a really engaging Q&A session as well. So as I say, thank you so much for joining us and sharing all your thoughts with us. And I'm sure I can speak on behalf of everyone that they'll have enjoyed listening to you on this virtual meeting. But as you said, it was a lot easier with these things had we been there in person. So just to finish and conclude, our next event will be on Tuesday, not on Monday, Tuesday the 24th of November at 6 p.m, when our guest speaker is Katherine Bennett CBE, who is Senior Vice President of Airbus. She leads the company's external engagement and strategy in the UK and works closely with the global CEO of Airbus. Also in July 2018, she founded and co-chairs actually, the UK's Women in Aviation and Aerospace Charter, which is committed to building a fair and balanced industry for women. I can also confirm a new date, which we had a question mark about at our last launch event, but that's later in the season, which is, we hope, might be a lunchtime event, and it's on Monday the 5th of July, when we will hear from Andrew Davis, who is Chief Executive of Kia Construction. But please keep an eye on the website for all details relating to the club.